I call the honourable member Dennis O'Rourke.
Thank you, Mr Speaker. New Zealand First is satisfied that all the amendments in this bill are minor and suitable for a statutes amendment bill. But I do have some comments to make on some of the parts. First of all, Part 11 has 2 amendments to the Judicial Conduct Commissioner and Judicial Conduct Panel Act. Quite a mouthful. The first one deals with the ability for the Commissioner to delegate to his or her deputy. This was something that we discussed in the Justice and Electoral Committee when we interviewed the Commissioner, and we felt that it was rather strange that such a delegation power didn't already exist, and that it was only a sensible use of the resource which is the deputy to assist the Commissioner himself or herself in their work. And we were concerned that the Commissioner might become overloaded. So I'm very glad to see that this minor amendment is included in the bill. The second amendment states that the Commissioner must dismiss a repetitive complaint. We were also concerned in the committee that there were a number of time wasters who made repetitive complaints which were not useful for anybody, so I'm glad to see that that particular amendment is here as well. With regard to Part 2, that deals with the Antarctica Environmental Protection Act 1994 and implements New Zealand's obligations under the 2009 agreement to amend the Antarctic Treaty for the purpose of improving the regime for taking or introducing species into Antarctica, a very important provision indeed. And this includes ice shelves and sea ice as well. It's a very welcome provision. It's one which is long overdue, and I'm very disappointed that it has in fact taken 5 long years to implement this. So perhaps we could have some explanation by the Minister why it took so long to do such an important thing. I want to move on to Part 17, which deals with the Local Government Official Information and Meetings Act 1987. Clause 50 amends Section 4 of that legislation and provides that the purposes are to include progressively increasing the availability of information to the public. There is, Mr Speaker, a high public demand for information from local authorities, and councils are notorious for, firstly, unnecessarily having meetings in public excluded, and secondly, being highly defensive about keeping information that they don't want known to themselves. It has a culture of it's our information, not the public's information, and that's a culture which has to change. So we actually need even stronger amendments than this. This is welcome for progressively improving the situation, but in fact what we need is something more stronger, and I hope that the government will look at something more stronger than that in the future. Also, Clause 56 clarifies that a local authority may refuse a request if the document alleged to contain the information cannot be found, despite reasonable efforts to locate it. That's actually a little bit dangerous when you think about it, because it's very easy for a local authority simply to say, well, we're not going to give you that document because we can't find it. And nobody would be the wiser for it. So I'm a little bit worried about that provision. It should really just be a defence rather than an authority to give that as a reason for refusing to give a document. So I'm a little bit disappointed in that provision. I don't think it's quite right, but it's not so serious that New Zealand First would vote against the whole bill. Mr Speaker, I want to move on to Part 23 because exactly the same issue arises there with the Official Information Act 1982. Clause 76 amends Section 18.2 to refuse to give documents for exactly the same reason. That is, that the document has been lost. So I repeat the same concerns I have in respect of that provision as I did with the Local Government Official Information and Meetings Act matter. Moving on to Part 24, this I think is quite important. It amends the Ombudsman Act 1965 And New Zealand First approves very much of the amendment for giving the Ombudsman the ability to refuse to commence an investigation of a complaint if he or she is satisfied that it is unnecessary to do so. Again, I was present at the Justice and Electoral Committee when we talked to the Ombudsman about this very issue, and it is actually quite a serious problem because a lot of time wasting can happen when the Ombudsman has to set out to investigate a complaint when he or she is sure that it is actually unnecessary to do so. The Ombudsman's time is very, very valuable, and I think we need to trust him or her to sift out those complaints which are unnecessary to investigate. So this amendment actually makes it possible to do that. We in New Zealand First think that's completely appropriate, and we are a little bit worried about the high workload that the Ombudsman has to work under. So this is also just a common sense way of making better use of the Ombudsman's time. So with those comments, Mr. Speaker, some concerns, but also some very welcome new provisions, which although minor are nevertheless very important in their own way. I think appropriate for a statutes amendment bill, a bill which is easy to gloss over, but which we all need to take particular notice of. And we in New Zealand First have studied it closely, and we think it deserves to pass, even with some of the reservations which I have expressed. Thank you.
Thank you, Mr. O'Rourke. I call the Honourable Member Louisa Wall. Tēnā koe, Ms. Wall.
Tēnā koe, Mr. Speaker. Thank you very much. I rise to speak at the first reading of the Statutes Amendment Bill